Hello, this is Matt on the Moon Lambeau channel. Is everybody out there ready to see the SEC utterly devastated and humiliated yet again regarding the SEC v. Ripple case? I sure as hell am. I'll be happy to see that. I'm sure most of you are now aware that the SEC has filed a request to file an appeal. And the question is this actually going to happen? What are the potential paths forward? Well, I'm going to break that down further because I have additional legal insight. Here you can see a headline on your screen from the Crypto Basic. Legal expert says Judge Torres will deny SEC's appeal request. And I'll just say here at the outset of my video that my for fun guess, which is nothing more than that because I am not an attorney, I just play one on YouTube, my for fun guess is that the appeal request, once it ultimately... if it's allowed to go through, it'll just be denied. I do believe that that's the most probable outcome, but there's a very respected attorney out there named James Murphy. In fact, I love his takes. He's just incredibly insightful, just a wealth of knowledge, legal knowledge and otherwise. And he's actually not quite as confident. So maybe perhaps it's more probable that, yeah, the appeal's not going to go through, but I'll share with you his specific words on this and the potential ways that it could break down, because there are a handful of things that he cited that I hadn't heard anybody else note as even potential options, and it really caught my interest. And then there's also this article from the Crypto Basic. Exchanges won't delist XRP even if SEC wins appeal. Hogan. That's right. Attorney Hogan has stated, and I mentioned on a video yesterday, but there's some more stuff to say, but even if it goes down that way, which is unlikely, even if SEC wins appeal, XRP is here to stay. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Damn it. Into the first piece. In the wake of the SEC requesting to file an interlocutory appeal in the Ripple lawsuit, former lawyer Scott Chamberlain has made an audacious prediction regarding the request. And just as a friendly reminder, interlocutory appeal, that would be the type of appeal request that occurs prior to the conclusion of adjudication, the conclusion of a lawsuit. It's to expedite the process of appeal because apparently in this case, the SEC thinks things have gone so off the rails, so horrifically wrong. We can't wait till the end of this lawsuit. We can't wait for the jury trials, brackets, anything. We need an appeal now because we're little baby back bitches at the SEC. And they, yeah, that's what they actually wrote. We're like, we know we're baby back trials, but sent that off to the Judge Torres. So I don't know, maybe it's like, well, a bunch of baby back bitches. Who knows? Maybe I'm wrong, and as a result, it does get approved. But anyway, piece continues. In a tweet today, Chamberlain speculated that Judge Annalisa Torres would deny the SEC's interlocutory appeal request. And here's what Scott Chamberlain actually had to say. My bet, Judge Torres denies the request. She studiously avoided new law. She found the token is not the security, accepted the SEC's characterization of the transaction buckets to be analyzed, and simply applied Howey and its progeny to the SEC's chosen buckets. SEC failed because the undisputed facts didn't support all the Howey prongs for 2 of its 3 chosen transaction buckets, not because Judge Torres shifted the legal goalposts on the definition of those prongs. Yeah, and so I'll add here also something that Attorney Deaton has pointed out on multiple occasions to this point. Even if there is an appeal that moves forward and the decision has to go back to Judge Torres as a result, she'll come to the same conclusion by ruling on a different prong of the Howey test, because she only talked about one of the prongs of the Howey test in her ruling. So she can easily go to the other ones and come to the same conclusion, which is why Attorney Deaton has articulated that this thing's dead in the water. So, but here again, former Attorney Chamberlain thinks it's not even going to make it that far. But Attorney James Murphy thinks it's actually a little bit closer than you might expect. And so here's what Attorney James Murphy had to say, known as Meta Lawman, all up on X, formerly known as Twitter. SEC/Ripple, words are hard this morning, Ripple interlocutory appeal analysis. This post will address what I see as Ripple's options in responding to the SEC's request to Judge Torres for certification of an interlocutory appeal. Option 1. Oppose the motion to certify the appeal. Ripple could say that the decision is obviously correct, so an interlocutory appeal to the Second Circuit just to confirm that fact would be a waste of time and would be inefficient because of the high likelihood of yet another appeal to come after the trial of Garlinghouse and Larson. Option 2, agree with the SEC that interlocutory appeal is appropriate. Okay, so I'll just pause and note. This is the one that most caught me off guard. This is a concept that I hadn't considered. Nobody else that I've seen in the world of crypto has even brought this potential up. And so again, he said, agree. This is an option for Ripple, and he's not it's probable or not. It's an option. Agree with the SEC that interlocutory appeal is appropriate. That's right, an option. Ripple could agree with the SEC. Yeah, we need an appeal. And then he says, while unlikely, this response would actually not shock me. Appeals are a virtual certainty in this case. The only question then is whether the appeals process will start now or a year or more from now after the trial of Garlinghouse and Larson. Okay, so I don't, to me, fine, I'm not the lawyer. It doesn't sound probable to me. But I don't see what the benefit would be. I mean, just get it over with now. Like, to me, the way that I look at it, you know, with all the pretrial stuff, it was to the SEC's, but it was a tactic, frankly, just to drag things out and like wear down Ripple, this or that. Not good for Ripple, not good for the future of Ripple's business, having things drag out. But now Ripple's in the driver's seat. XRP's got the legal clarity that it needs. What would then be the rush for Ripple, to get to appeal land? Like, why would we want to get to the appeal part if we're Ripple? Like, I don't see that as probable unless I'm missing something. But again, he's just citing potential things that could occur. And then he says option 2A. Agree that interlocutory appeal is appropriate, but add that the one claim that the SEC won on institutional sales should also be certified for a cross appeal by Ripple. The logic for option 2A being that if the Second Circuit reversed the SEC's win on the institutional sales claim, then everybody is saved the trouble of going through a penalty phase, and there would be no need for a trial on aiding and abetting the institutional sales. Okay, so think about it. So that would be the only potential upside, but that doesn't impact Ripple, which is why I'm thinking, okay, you're going to go that route, an early appeal, and say, yeah, we agree with that stipulation, and then hope that it would just help Brad and Chris? Because Ripple's not at play there. That's not what the jury's for. That's not what the trial's for. So I'm still kind of got a little question mark on that one as to why that would be something that would genuinely be considered there. But what does Attorney Murphy think will happen here? Well, he says, quote, I think Ripple will go for option 1, number 1 above. Oppose the request for interlocutory appeal. There are 3 reasons for this, and this gets extra interesting. So I thought the concept of potentially, Ripple agreeing was interesting, but this, just hang with me here. So there's 3 reasons. Number 1, Ripple does not want to agree with the premise that there is substantial grounds for difference of opinion on Judge Torres' ruling, which is part of the legal standard for certifying an interlocutory appeal. Ripple's position is that Judge Torres' ruling is clearly correct on secondary market sales of XRP and consistent with decades of precedent. Number 2, while highly unlikely, there is a non-zero chance that a crypto law could pass Congress and be signed into law. That legislation could conceivably characterize the original institutional sales of XRP as not securities transactions because the institutional buyers of those tokens did not receive equity or legal rights to participate in profits generated by Ripple in exchange for their money. Admittedly, a long shot. Okay, now there's this one, and this is the one where I was like, check this out. He says there is a chance, fill in your own percent, that a new administration, what I was thinking of comes right after this, actually, but this is still interesting. There is a chance, fill in your own percentage, that a new administration will arrive on the scene in January of 2025 with a very different view of the SEC's approach to crypto enforcement actions. That new administration, with new leadership at the SEC, could either immediately dismiss the case or settle on terms favorable to Ripple. For these reasons, I believe Ripple is more likely to choose the slower route and, therefore, oppose the interlocutory appeal. Yeah, and so that's what I think sounds most probable, and I think most attorneys that I've read perspective from have pretty well agreed on that. But so here's the part that I actually thought I was about to read that is exciting and just kind of was like, when I read this. What will Judge Torres do here? Because he's proposing there's actually a reasonable possibility she might do something that we haven't been considering at all. Check it out. Attorney Murphy says, I believe this is a much closer call than most people think. Normally, requests to certify interlocutory appeals are given very little chance of success. And so I'll pause to note here. What I'm going to read next from Attorney Murphy, he does cite the perspective of Judge Rakoff, which is it's a judge in the same district as Judge Torres. That's the judge in the Terra case, the Terra Luna case, Do Kwon, the Terra that collapsed in May of last year that caused the contagion, as everybody was calling it last year, the cascading effects with Three Arrows Capital falling and all that crap. Well, Judge Rakoff ended up opining on the Ripple case, and he went against, to a certain degree, Judge Torres. I'm assuming most of you are aware of that, but just in case I had to mention that, or else this next part, which is actually really important, wouldn't make sense to you. So that's Judge Rakoff, the renegade judge, and here's what Attorney Murphy had to say. But Judge Rakoff's decision in the Terraform Labs case makes it far more likely that Judge Torres will take that unusual step and certify the interlocutory appeal. Okay, whoa, now that's something I'd not heard from anybody else. So because Judge Rakoff came out and said the nonsense that he said, now, in Attorney Murphy's perspective, that makes it to whatever degree more likely that Judge Torres actually will say, well, okay, Judge, even in my own district, okay, let's go ahead and sign this thing. Let's get this appeal process underway. Huh. Well, that would be interesting. I don't know what the probability of that is, but that's an interesting concept I've not heard from anybody else. But, even if it happens, and I mentioned this the other day, but it's worth repeating because it's just such an interesting stat. Two stats that I just had kind of gives you an idea of what's maybe perhaps probable for the future. When it comes to appeal, Judge Torres she's never had a decision that was reversed, not once. Attorney Deaton reported on that. You know what else Attorney Deaton reported on? That Judge Rakoff, he's had decisions reversed, I think it was 56 times. It was maybe either 53 or 56 times. Whatever the numbers, we're splitting hairs at that point. It's a lot. Renegade judge, my friends. So we'll see. And then he notes, I will give you my final prediction on what Judge Torres will do after the briefing on the motion to certify has been completed. That briefing should take about a month. I'll tell you this, the insight from Attorney Murphy I very much appreciate because he always has like a different, to some degree, like a different take than a lot of other attorneys in this space. And I guess you could say that's true pretty much all of them, but I just consistently find that's particularly true of him. And then there's this from the Crypto Basic. Exchanges won't delist XRP even if SEC wins appeal. Hogan. And that's good news. And I suspect he's absolutely correct here. Check this out. And I'm cited in this article, which is the real reason that I want to highlight this. Let's stroke my ego, because I have a gigantic ego, right? Piece reads as follows. XRP will not be delisted on exchanges, irrespective of whether the SEC wins its appeal against Ripple. Recall that the Securities and Exchange Commission requested to file an interlocutory appeal in the Ripple lawsuit. As reported, the SEC's interlocutory appeal will cover Judge Torres' decision on Ripple's programmatic sales and other distributions. Notably, several XRP enthusiasts are concerned about the implications of a higher court declaring Ripple's programmatic XRP sales securities. And check this out. In a tweet today, prominent XRP YouTuber Moon Lambo, it's right, prominent bitches, prominent XRP YouTuber Moon Lambo. Son, you don't even know if I'm wearing pants or not. And I'm called Moon Lambo. No, I appreciate it, though. They're being very kind here. Thank you very much, the Crypto Basic. Prominent XRP YouTuber Moon Lambo. All up in his badge. And they actually, the part of the reason I wanted to highlight this also, in addition to the fact that it's funny that I'm called a prominent XRP YouTuber, is they did get something slightly incorrect. I'm not going to go too hard in the paint on them for this, but just want to just clarify. So anyway, they're right here. In a tweet today, prominent XRP YouTuber. I gotta change my my profile on X, formerly known as Twitter. I should probably update my LinkedIn. Certified as prominent by the Crypto Basic. There's some changes that gotta be made in my life. Anyway, in a tweet today, prominent XRP YouTuber Moon Lambo speculated that XRP secondary market trading would be affected if all programmatic sales were found to be securities. And then they quoted me as follows. Isn't that the functional equivalent of XRP being a security in such a hypothetical? End quote. So there's the thing, and they wrote that I was speculating that such is true, but they quoted me, and I think they quoted me accurately. I'm pretty sure. I'd have to go back and double check, but I think they quoted me accurately. And you will note that that is not me making an assertion. That is me asking a question. That is me having a lack of certainty, seeking answers. So I was not just to be clear, I was not speculating that programmatic sales would be found to be securities, but I wanted to know the status. And we did find ultimately that programmatic sales, no, they're not. And there's a very simple reason for that. The reason that programmatic, or well, not as it pertains to us anyway, it's because Judge Torres' ruling on programmatic sales only applied to Ripple and Brad and Chris. That's it. That's it. So even if they were appealed and even if it were overturned, that does nothing to change the legal status of XRP. The legal status of XRP wasn't even a part of the decision on programmatic sales, and it wasn't part of what the judge was required to rule on even. It's what's known as dicta. So there's this optional, perspective that she put in there, and so it is the standing law, but it's not even something that the SEC can actually appeal. So XRP absolutely, unquestionably, is not a security. That is the legal status. And then Attorney Hogan added some additional clarity, and he wrote, only Ripple and other founders can sell XRP as an investment contract, so I don't think they will delist as long as they can source XRP from the secondary market and not from Ripple directly. Yeah, so that's what I would expect is the case. But the SEC's backed in a corner here. Like they really, there's nothing they can do. That's why Gary Gensler very recently, just a number of days ago, maybe it was a week ago, whatever it's been, he announced that he's going to take a hard look at AI. So apparently artificial intelligence is now security stuff. Have fun, AI nerds, because Gary's coming for you. Good luck. Good luck. But yeah, they're not going to have as strong a focus on crypto, it looks like, because this is absolutely crippling to them, honestly. Finding XRP not a security because you know what's going to happen in all likelihood if they were to continue prosecuting individual developers building on top of specific blockchains that have cryptocurrencies native to them. Probably not going to go well. Because even if it's not binding precedent, even if it weren't in other courts, might this weigh heavily? Might this weigh? And either way, understand, as it pertains to XRP, there is no question mark there. This is a question of do you have to apply that to other, and no, in that sense, it's not binding for other projects. Apparently you need I don't know to what degree higher court, I don't know if that would be appellate court or if it'd have to go to the Supreme Court, probably appellate. But anyway, we're safe. That's the point. That's what actually matters here. And prominent XRP YouTuber Moon Lambo has said that it's so. That's how you know that it is so. Because I'm prominent, bitches. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo, which is prominent.